All right. Thank you very much.
Thank you.
Thank you.
We'll come back to you. Let's go to number 10, United Homeowners. Who do I have on the line for petitioner? Do I have anyone on the line? Anyone on the line for United Homeowners?
Yes, Your Honor. Kimberly Lewis is here on behalf of Real Party in Interest, Bedford Investments and Peak Capital.
And Elliot Thompson as well for Bedford and Peak. Thank you, Your Honor.
Thank you very much.
Good morning, Your Honor. This is Kiva Ridge-Muir on behalf of County of Los Angeles and Los Angeles County Board of Supervisors.
Thank you. Elliot Thompson. Do I have anybody for petitioner? There. Is it Ms. Grossman Palmer? She's right there. She's probably having trouble.
Your Honor, this is Kimberly Lewis for Real Party. I can see Ms. Palmer, the counsel for the petitioner, on my screen, but I can't hear her.
Okay. And Ms. Grossman Palmer is also on Fix the City, which was the other case that I couldn't reach anyone on.
She's holding something up to the screen that says will call back in, I think.
Oh, great.
We'll dial in.
Okay. We'll dial in.
Thank you. I'll wait. Ms. Grossman Palmer, were you successful? Yeah. Or must you communicate by cue card? I see her in the screen. Ms. Grossman Palmer?
Yes, Your Honor. I think my line has been unmuted. If you could hold 1 second while I turn the volume on my computer down, that would be helpful. Thank you. Okay, thank you, Your Honor.
Okay, so I've got the county, I've got Real Parties, and now I have Ms. Grossman Palmer on behalf of the petitioner. Ms. Grossman Palmer, would you like to be heard on the tentative?
Yes, Your Honor. I agree with much of the court's analysis in the tentative that petitioners are a prevailing party and that petitioners' rates are reasonable. I won't really get into the reductions on the hours, but I do want to address the issue of reduction based on limited success and specifically the reliance on the source case. In that case, it's a little unclear what relief the petitioner achieved. That case involved, the case says that the petitioner raised challenges not only with CEQA but also to the approval of the project on the basis of a violation of a number of local zoning ordinances. And it's not clear from that case whether an EIR was even required to be prepared as a result of the writ being issued. It simply said that the MND and CUP were vacated and they were ordered to comply with CEQA in approving the project in the future. So the analysis is whether the relief is limited in comparison to the scope of the litigation as a whole. And so I don't think, based on the source case, that a 40% reduction is justified here. There were, I mean, as the court is aware, of course, any litigation involves lots of non-issue specific activities. So it's not really proper to do a mathematical, you've won on one issue, but you raised 4 issues. As to the contention that we abandoned one challenge on greenhouse gases, we also did not spend any time on that challenge to abandon it, so it didn't really result in any increase in the fees. As to land use, I would take issue with the statement that we provided no legal authority. The court didn't agree that the court said that we did not show the zoning ordinance that we raised as a basis for land use inconsistency to have been enacted for the protection of environmental conditions, or to protect, as a protective ordinance, I'll say. But that does not mean that we provided no legal authority. So I would say that a reduction of 40% is far too significant in light of the fact that petitioners achieved their litigation objectives, and an environmental impact report is being required to be prepared that will comply with CEQA and contain analysis of all the project alternatives, which is a key thing that that United Homeowners was seeking to achieve. It's like an actual reasoned analysis of projects that may lessen the impact of the proposed project. So I will leave it at that, that I would urge the court to revisit that size of that reduction in light of the source case, its different facts, and the petitioner achieving the relief that it sought out to achieve.
Thank you very much. On behalf of Real Party.
Yes, Your Honor, this is Kimberly Lewis, and thank you for your tentative. First, I'm going to respond to just a couple of things that were in the tentative, and then I'll address the arguments that Ms. Palmer just advanced. First, Your Honor, at page 3 of your tentative, you indicated that you were hoping that we weren't suggesting that the county was not going to undertake a meaningful CEQA review, and that is certainly not what the argument that we were advancing in that section of our brief. The point that I was trying to make is that in reviewing the cases, this case seems remarkably similar to the La Habra case, and so that in which the case denied attorney's fees completely, and the issue in that case was a citizens group trying to stop a Costco, and the court found that there was just limited relief, and even though an EIR was ultimately prepared. But I don't want to spend a lot of time on that, but no, we were not trying to suggest that there will not be a meaningful review. The county will do what they need to do. The second point that I wanted to make was regarding the reduction on the attorney's fees motion, and your court correctly noted that the initial amount requested was too high and reduced it accordingly. And I wanted to point out to the court's attention that in the declaration that Ms. Palmer submitted to justify the $21,000 that they are now seeking, or $22,000, she indicated at paragraph 4 of her reply declaration that this was time we spent preparing this reply brief and in opposition to a motion to tax costs. That's how she says she got to the 22 hours. There was no motion to tax costs in this case. So to the extent that she has the 22 hours, that number is on its face inaccurate and must be further reduced. The last point that I want to make is our reliance on the limited success rule is certainly not limited to just the source case. There are legions of cases pointing out that when a party achieves only limited success, the fees must be reduced accordingly. And those cases start with the U.S. Supreme Court and go all the way down to the Second Circuit. And many of them have been cited in the brief. In fact, I will point out that in many of the cases that petitioners themselves relied on, such as Riverwatch versus County of San Diego, 175 Cal. 4768, the court reduced the fees there by 50% because they only had a limited success. Even in cases Agora Cornell Knoll, in which the petitioner had an excellent result, one could say, because they knocked it out on several different cases, it still reduced the fees. So Your Honor is on strong ground in reducing the fees in this matter based on the reasons given. And we would assert that a further reduction is warranted given the fact that the ruling, it stands now, its judgment, they showed up at the trial, they had a laundry list of claims, most of them were not pursued. We can identify the billable hours spent on land use, and the court's ruling was they provided no cites to the administrative record, no supporting authority, and so we would urge the court that a further downward revision is warranted.
Let me just say, on that attorney fee petition, I found the appropriate lodestar was 16 hours at the $6.95 an hour. So I recognize that in the initial motion, there was $22,000 that was requested. In the reply, Ms. Grossman-Palmer indicated that it was an estimate and reduced it further, I think, to a total of 21 hours, and I think I reduced it from there, given the hourly fee that's involved at $6.95, to a lodestar amount of 16 hours times the $6.95. So I did reduce the attorney fee motion. Ms. Grossman-Palmer, would you like to respond to anything since you're the moving party that Ms. Lewis said?
Your Honor, no, I don't think that there is. There is an error in the declaration. There was no motion to tax, and that is evident if you review the billing records. So we did not seek any hours for any motion, any fees, or any motion to tax costs. And I do also just want to make sure that the court realizes there was no motion to tax costs, and so the cost memorandum is, of course, final, and petitioners are deemed to be awarded those costs as well. And so, Your Honor, I don't have any specific responses to counsel's arguments there. As I said earlier, I think the 40% is quite high of a reduction in this case, given the results obtained, and I would urge the court to consider a smaller reduction for limited success.
I knew that you did not, I knew that there was no motion to tax filed, because there's that, I put in the footnote about the memo of costs, and that's a ministerial issue for the clerk to enter into the judgment when there's no motion to tax. So I did know that, and to be completely honest, I'm not sure that I saw the language that Ms. Lewis pointed out, but I do know that I looked at and evaluated that attorney fee motion and adjusted the lodestar for that. So let me read the source case and look at the other cases that Ms. Lewis cited, and I will issue an order. All right?
Thank you, Your Honor.
Thank you, Your Honor.
Thank you for your patience. I'll stay on the phone.
Yeah, so I'm going to go back to Palmer's other case. Well, I guess she has a couple. Let me just handle number 3, which is Fix the City, which is here for a trial setting conference. Ms. Grossman-Palmer, you represent the petitioner, is that correct?
Yes, Your Honor.
Thank you very much. And I know there's an outstanding notice of related cases, correct?
Do you mean that there is a third related case?
I think that, I know that on one of your cases, I thought it was this case, but it may be the motion to strike case, that there's a pending notice of related case, correct?
Yes, all three of those cases raise the same legal issues.
Understood. Okay. So who is representing the city on number 3, Fix the City, which ends in 355, the case number?
Good morning, Your Honor. Donna Wong for the City of Los Angeles on the Fix the City case ending in 355.
Thank you very much. And the party in the Fix the City case ending in 355.
Sorry, Your Honor. I'm with the defendant, the Westwood LLC, Bob Bolbahar.
Are you on 355? Case number
Yes,
ending
sir.
355? Okay.
Yes, sir.
Okay. Ms. Grossman Palmer, it's a 1094.5 as well as a 1085. What can you tell me about the record?
Your Honor, this case is likely not going to proceed